Craig v. Boren, 429 U.S. 190, 1976, was the first case in which a majority of the United States Supreme Court determined that statutory or administrative sex classifications were subject to intermediate scrutiny under the 14th Amendment's Equal Protection Clause. Facts: Oklahoma passed a statute prohibiting the sale of non-intoxicating 3.2% beer to males under the age of 21 but allowed females over the age of 18 to purchase it. The statute was challenged as 14th Amendment equal protection violation by Curtis Craig, a male who was over 18 but under 21, and Carolyn Whitener, an Oklahoma vendor of alcohol. The nominal defendant was David Boren, who was sued ex officio by virtue of his serving as governor of Oklahoma at the time of the lawsuit. Ruth Bader Ginsburg, working an attorney for the ACLU, advised plaintiff's attorney, submitted an amicus brief, and was present at counsel table during oral argument before the Supreme Court. Issue: the Supreme Court was called upon to determine whether a statute that denies the sale of beer to individuals of the same age based on their gender violates the Equal Protection Clause. Additionally, the Supreme Court examined for jus tertii, third-party rights, in this case the vendor of the 3.2% beer. Result: Justice William J. Brennan delivered the opinion of the court, in which he was joined by Justices White, Marshall, Powell, and Stevens. Justice Blackmun joined all but one part of the opinion. Blackmun, Powell, Stevens, and Stewart wrote concurrences. The court held that the gender classifications made by the Oklahoma statute were unconstitutional because the statistics relied on by the state were insufficient to show a substantial relationship between the statute and the benefits intended to stem from it. The court instituted a standard, dubbed intermediate scrutiny, whereby the state must prove the existence of specific important governmental objectives, and the law must be substantially related to the achievement of those objectives. As to third-party rights, the court, expanding on the doctrine of standing, held that the vendors of 3.2% beer would be economically affected due to the restrictive nature of the sales to males between 18 and 20. To have standing, one must show a nexus of the injury to oneself and the constitutional violation of the statute. In this case, the statute directly affected Whitener only economically, but the Supreme Court explains that Whitener and other vendors have standing to assert concomitant rights of other parties, such as Craig. The court acknowledged that parties economically affected by regulations may challenge those regulations by acting as advocates of the rights of third parties who seek access to their market or function. Justice Blackmun wrote a concurring opinion, agreeing that a higher standard of scrutiny was appropriate. Dissent: Chief Justice Berger and Justice Rehnquist dissented. Rehnquist dissented because he felt that the law only needed to pass the rational basis analysis. Previous cases in this area, such as Stanton v. Stanton, had used only the rational basis test. Berger was in general agreement with Mr. Justice Rehnquist's dissent, but penned a separate dissent to emphasize that a litigant may only assert his own constitutional rights or immunities. He felt that the indirect economic injury to Whitener and other vendors introduced a new concept of constitutional standing to which I cannot subscribe.
Please subscribe and thanks for watching.